The exercise of the High Court regard to the present habeas corpus application before. We know that a clear plea of that particular order of the court. The High Court asked the relevant authorities to produce the warrant or order of detention.
It's okay, Counsel, I can read. So maybe the prosecution can bring.
The High Court insists. This magistrate.
Your name is Jerome for the state.
Miss.
We have just this morning been served,
Okay.
We have just this morning been served with the order for habeas corpus while we were seated here in court. And a quick perusal of the order reveals that there is no stay forbidding or otherwise stopping the accused person from taking. Your Honor, it is rather insincere for defense to allude that the motive of the state arraigning the suspect in court this morning is to defeat the purpose of the habeas, which order we have just been served with this morning. Your Honor, in addition, Counsel has also not demonstrated the manner in which the rights of the suspect has been infringed on, if any at all. Your Honor, if at all the rights of the suspect have been infringed in any manner whatsoever, recourse lies in the High Court. And nothing stops the defense from moving the High Court appropriately. Our prayer, therefore, Your Honor, is that the suspect should go ahead and take plea, as there is no material that has been presented before this court that acts as a stay. Thank you.
I cannot quickly join. With regard to service of the order, you know what we have placed before you. This was an order issued on the 8th of July, and it's duly received and stamped on the 8th of July. If their clients did not deem it fit to disclose this information to the Office of the Director of Public Prosecution, this cannot be placed on the feet of my clients or myself. The order was served in a timely manner. Lack of knowledge of the same by the Office of the DPP falls squarely upon their client. In the Directorate of Criminal Investigations, the IG of the police, and Sub-County Criminal Investigating Officer Juta. You cannot therefore rely on that ground to defeat the application for plea to be deferred. You have been
Brief rejoinder, counsel.
yes, it's a brief
Brief
rejoinder.
rejoinder, is that
Yes,
a
yes,
brief
but there
rejoinder?
was some admonition that I was being insincere, which I need to clarify, Your Honor. Your Honor, it does not take a professor of law to see what is before you. Your Honor, an order was served upon them to produce the accused person before the High Court tomorrow at the 10, alongside an order of detention. Following said service, they have produced the accused person before you with the clear and only goal of acquiring a warrant of detention with which they shall produce it before the High Court. This is not far-fetched. It can clearly be seen from the actions. It's a necessary implication of the order. With regards to the issue of that recourse being sought before the High Court, the intended accused has already done. And an order has been issued. And it is before you. The Superior Court has acquired jurisdiction with regards to the accused person. And given the hierarchy and supremacy of the courts, given the hierarchy of the courts, Your Honor, it behooves you, on your rules, let the High Court proceed and conclude the issue of the violation of his rights, given that your jurisdiction under Section 8 is very limited.
Yes, counsel, and you should not try to instruct the court on how to proceed.
Your Honor, I am not instructing you. I'm making
Yes, and the
submission
law
on
is
behalf of
very
my client.
clear, so if you have submissions to make, just stick to the law without looking like you're supervising them.
Your Honor, hierarchy of the court is a matter of
It
law.
is okay, the law is clear and the court will visit that in its directions. Are we together? Yes. See, the
Your
law
Honor,
is
you also
clear.
not seem to be holding brief for the only.
Okay, counsel, your comments are noted.
Also right.
Yes, I'm having problems with my laptop. It's not responding. Please, the file service. So place the file aside as we fix the laptop. Next.
Shadrach Kibova Mutunga. Shadrach Kibova Mutunga ana miaka ngapi? 17.
How long does it take to conduct age assessment? Yes. Because even if he says if he's a minor, the same should be done in all the cases. Yes. So that you can take the correct. So I direct the accused be taken for age assessment. Mention for taken.
Friday.
Yes. Yes.
We don't want to be for people.
And Friday is which date?
11 days.
Utapelekwa ukapima miaka, alafu baada ya kupima miaka utaletwa kotini on Friday kusoma mashtaka baada ya koti ya miaka kuweka kotini. Alan Kiama wa Moi. Gabriel Ochieng. Alan Kiama. Gabriel Ochieng. Alan Kiama na Gabriel Ochieng wameshtakiwa na kosa la kuvunja store kinyume na sheria. Maelezo ya kesi inasemekana kwa tarehe 24 mwezi wa 5 na tarehe 1 mwezi wa 7 katika Malaba area na pia sub county Kiambu County. Yote kwa pamoja na wengine ambao hawako mbele ya mahakama waliweza kuvunja na kuingia store ambayo ni ya Monica Karanja nikiwa na nia ya kufanya uharibifu. Mshtakiwa kwanza leo ni kila masikini.
Sikweli.
Mshtakiwa pili Gedra. Mshtakiwa na kosa la pili, kosa la wizi kinyume na sheria. Maelezo ya kesi inasemekana kwa tarehe 24 mwezi wa 5 na tarehe 1 mwezi wa 7 mwaka huu katika Malaba area, Juja sub county, Kiambu County, kwa pamoja na wengine ambao hawako mbele ya mahakama, waweza kuiba bags za simiti, 180 bags za simiti. Pesa yake ni 137,700 na pia mkaweza kuiba bidhaa za kupima mbao feet ambayo ni dhamana ya shilingi 75,000. Zote kwa pamoja ni 212,000 mali ya Monica Karanja. Mshtakiwa wa kwanza leo ni kila masikweli.
Sikweli.
Mshtakiwa wa pili.
Bond of 200,000 with surety and security of a similar amount or cash bail of 150,000 mentioned.
The petition of August Young,
Hearing.
the 22nd of October, court number 2, 22nd of October. Kila mmoja wenu amekabidhiwa bond ya 200,000 ama pesa taslimu 150,000. Weza kulipa mtakisi kisini kwa nje kama mtaweza kulipa. Tarehe 15 mwezi wa 8 mtaitika gerezani. Kesi itasikizwa tarehe 22 mwezi wa 10, court number 2. Christopher Nyongesa Otieno. Christopher Nyongesa. Christopher Nyongesa Otieno ameshtakiwa na kosa la uvunjaji wa nyumba kinyume na sheria. Maelezo ya kesi inasemekana kuwa tarehe 3 mwezi wa 7 katika Makongeni Landless Area Thika Sub County, Kiambu County uliweza kuvunja na kuingia nyumba ya Kenneth Mugo Waihaka ukiwa na nia ya kufanya uhalifu. Ni kweli ama si kweli? Tuone. Kiongozi wa mashtaka anaomba atoe tarehe ndio aweze kusoma maelezo ya kesi. On the 6th of August. Before court. Waletwa kotini tarehe 6 mwezi wa 8 kusoma maelezo ya kesi. Mildred Hasita Lumumba Mildred. Mildred, simama tafadhali. Mildred Hasita Lumumba mshtakiwa na kosa la kutekeleza mtoto kinyume na sheria. Maelezo ya kesi inasemekana kuwa tarehe 6 mwezi wa 7 Kiganja Area Thika Sub County, Kiambu County. Wewe ukiwa mzazi wa mtoto ambaye ni wa umri wa miaka 14, kwa kupenda ulimtekeleza huyo mtoto kwa kumwacha awe ni mtoto ambaye anahitaji protection na care, ulimwachilia. Ni kweli ama si kweli? Tuone. Mshtakiwa na kosa la pili kumtekeleza mtoto. Kumtelekeza mtoto kinyume na sheria. Maelezo ya kesi inasemekana kuwa tarehe 6 mwezi wa 7 Kiganja Area Thika Sub County, Kiambu County, ikiwa mama wa mtoto ambaye umri wake ni 14, kwa kupenda ulimwachilia huyo mtoto. Ni kweli ama si kweli? Ni kweli. Tuone. That's 12th of August before court number 6.
The children officer filed a children officer's report.
Tuleta kotini tarehe 12 mwezi wa 8, children officer atafungua file ambayo itaangalia watoto. Mariam Achieng Modaho. Mariam Achieng. Mariam Achieng Modaho mshtakiwa na kosa la kuchapa na kumjeruhi mtu kinyume na sheria. Maelezo ya kesi inasemekana kuwa tarehe 6 mwezi wa 7 katika Nyasava Center, Thika Sub County, Kiambu County. Wewe na kwa pamoja wengine wako mbele ya mahakama iliweza kumchapa na kumjeruhi Simon Geshere Matipa. Ni kweli ama si kweli? Uko na miaka ngapi?
We also ready.
That's what you
Saidiana. Finish. We highlighted, but we have better points to argue.
James Mondi. James Mwangi.
Check how old she is.
Daniel Tege.
Oh.
Francis Mora. Mani Aziza. Dennis Maina. Justus Musua. Victor Kinyambui. Raymond Mushigi. Mary Nyambura Rosa. Michael Kadai. Maina Kariuki. David Mwangi. Nathan Mugere. Edwin Mugwa. John Nana. Esther Wanjiku. Mercy Wanjohi. Eric Mwanja. Mwaniki Soiteki. Daniel Sidari. John Karanja. David Yanga.
Kuna demu anakaa mtaani mtu hata masi muulize age. Yeah. That's how they do. That is nice. That is what we want. That is I'm free.
Moses Mwangi. John Opio Oundo. Rogas Green. Francis Mwangi. Edmond Michel. Simon Kamau. Simon Jung.
Only John, eh? On the client.
Eliud Mwangi. Felix Otieno. Brian Yoko. Lucas Mogo. Sean Juma. Brian Monene. Peter Juma. Samuel Ndegwa. Joseph Kamau. Joseph Njeri Ngoni. Michael Maura Wainina alias Michael Juni. Brian Duma Wainina alias Joseph Nangatu. Samson Maura. Tom Lee. Brian Karanja.
We'll take more time arguing that.
Francis Dukuna.
Let's just argue it. Sleep, bro.
Peter Njobe.
So yeah, it's fine, but I don't want. But we can join based on that.
Good afternoon, Your Honor. If it may please you, in the matter of Mr. Abner Mango, kindly place me on record for the suspects, for the 58 suspects. Your Honor, I do appear alongside Mr. Babu Wino, Ms. Wajira Maina, Mr. James Ongoma, Mr. Nurdin Kagai, and Mr. Kelvin Michuki.
I am present.
Your Honor, the matter is coming up under miscellaneous application. We are ready to proceed.
Your Honor, in the matter of Mr. Rombe for the state, I appear alongside Ms. Otisiko, and Mr. Ngao. In this application, is hinged on Article 49 G, H, and I, and the state is seeking for the continued detention of the suspects for a period of 10 days. The investigating officer who is before the court inspectors Bondo
The respondents, after they were arrested, the offense which they committed was within the Jinja sub-county. Which involved destruction of property, looting, forced entry to legal police station, threat to safety, order and national security. Your Honor, when the suspects, before they were arrested, they landed Buga police station. That was around 13:00 hours when they started howling stones and all kinds of projectiles to police officers who are manning Buga police station. This continued for almost the whole day until in the evening at around 6 when they were reversed by police officers. And during the time they were being reversed, they as well damaged police vehicles, that is GK B792W and GK B837V Land Cruiser, which they shattered their windscreens. Then after being reversed, they all went in different directions, and most of them, who were numbering around 1,500, managed to enter into Malay supermarket, which they broke the doors, and as well, they injured the workers who had already locked themselves inside the supermarket. The supermarket is about 400 meters from the station. When we received alert, police officers rushed to the scene and managed to arrest the 58 having robbed, jointly with others who managed to escape. The employees and members of the public.
Perhaps just for the sake of the court getting the proper picture, you have indicated to court that these respondents attacked the police station at about 1300 hours. What time were they allegedly at Malay supermarket, and what time were they arrested, and how were they arrested?
They were arrested at around 20:00 hours. And how they don't fear police officers. They also claim that they can also fight back and they are ready to be defended.
Objection, Your Honor. That line of submission in the application is not grounded in the application. It's submitting from the dock. We have not seen any such submissions in the face of the application.
I was a eyewitness, and I will also testify before court.
Then if he's willing to be cross-examined, then very well, we'll take that line.
So, Your Honor, I have compelling reasons as to why they should be detained, because none of them has, we have known is abroad. His place of residence. And for these offenses are so serious, we need more time to investigate thoroughly so that we may prepare the charges, record statements from fathers of witnesses who have not yet turned up but have reported to the station. We also need to get an audit report from Madai supermarket for the items and goods which were looted.
Are you talking of audit or inventory?
Inventory plus audit of items.
So, Inspector, it is your assertion that these suspects were arrested inside the supermarket?
That is true.
Now, this supermarket being private property, does it have any CCTV footage or any such?
If you have questions, we cannot cross-examine somebody. What do we do?
Is that all, or is something else that you wish to add?
That's all.
Just for purposes of good order and sanity of record, I just want to get clarification whether my colleagues wish to cross-examine me, and then we submit.
Yes. No, we cross-examine.
It's part of cross-examination.
Good afternoon, Mr.
Bondo.
Mr. Jarius Bondo. Yes, I'll ask you a few questions. I hope you have the application with you. What are the orders that you seek in your application, the instant application?
I'm seeking for the suspect to be retained at the police station for 10 days.
I want you to have a look at order number 2 as framed. Is in that order ambiguous from the framing of the said order? Order number 2 on your application. It's the same application you have. So what are you asking this honorable court? From the face of order number 2. Where?
Kibi police station.
No, read your application. I draw you to the last sentence. Where exactly do you seek to detain the suspect?
Be detained at Kibi police station.
For 10 days from today at Juja police station. So where exactly?
It is within Juja. That is
so you are not sure? You are not even sure. Thank you. So on to the second question. On to the second question. You are part of the investigating officers in this matter?
Yes.
Did you take time to ascertain the age of the 58 respondents?
Yes, I did.
Can you affirm to this court whether or not they are all of majority age?
All of them, there is none who is under 19 years.
I wish to draw your attention to the 24th respondent. Mercy Wanjoy, the 24th respondent. Mercy Wanjoy. Did you take time to ascertain the age of the
She told me she's 19 years old.
Did you take time to ascertain as an investigating officer?
That is the reason why
An officer of the court.
requesting for more time to investigate.
Investigate or ascertain the age.
I will ascertain when I'm investigating.
So you're doing things the wrong way.
That's constitutional.
So I wish to draw you to the contents of paragraph 5 on the ground in support. You allude to widespread destruction, looting of property, and forcible entry into the station. Have you provided in your supporting affidavit any annexure in support of the same?
We have photographs.
Have you annexed as you stand on the dock?
I will provide them the moment I will be testifying before court after.
So your government under paragraph 5 is premature.
I am requesting time to inquire and investigate for that and will bring footage.
I will step it up and draw you to paragraph 6, where you say that you have recovered exhibits, to mean that they are within your record or custody. True or false?
Yes.
So have you presented before this court any photographs, any inventory of things that you have recovered as exhibits?
I will provide them when
So you will futuristically. Sorry?
after investigation and
So at the time of drawing and filing this application, paragraph number 6 is an averment, is a mere allegation. You cannot prove it, that you have the exhibits.
I have this.
Where are they?
They are at the station.
What are they doing there? Yet you have said you have provided exhibits.
This is not, we are not, this is an application of making.
Now, you have averred that due to the activities of Sabasaba, there were reported injuries. True or false?
Yes.
To the police officers?
Yes.
So, is there any medical report that you have presented before this court to ascertain the nature?
Even they are going to be given with reforms.
Have you annexed any? From where we stand, can you ascertain the number, nature of injuries?
They have recorded their names in the current book.
My questions are yes or no. Have you annexed any medical reports
Yes.
in your application? You have.
Yes.
Please draw me to.
Next.
Yes?
Yes.
You have annexed.
It will be annexed.
So you have
By
not.
the time I will testify.
Thank you.
This is not.
You have alluded while answering to OB reports. Have you provided the OB report numbers?
Okay, is 29 of.
No, that is for the arrest. I'm asking for the injuries. You've said they are OBs. Have you provided those OB numbers?
I'm yet to record the statements.
So you are yet to do anything
Yes.
rather than arrest. So you have not done
Yeah,
zero
I haven't done
investigations.
anything so far.
You have done nothing so far. Thank you. You want to leave it at that? I'll leave it to my colleague too.
Mr. Mbondo,
Yes.
I will just pick it up from where he left. So you have said that you are here to do investigations.
I'm here to request to tell to finalize my investigation.
So if you are here to do investigations, where are they arrested?
Because you were arrested on the spot.
What follows? Investigation or arrest? What starts? Do you arrest someone, then investigate, or do you investigate and arrest?
They were demonstrating, and immediately after that, they went to commit an offense.
Committed an offense. That is what you're saying. You have talked about an OB number 29072725, right? Is that OB anywhere in your debit? Because that's just a number. Have you shared the same with the court? Do you have a copy of that complaint?
When you request it, we shall bring it.
What follows? What follows? You swear something without an evidence?
The OB is there. It is written.
So we can't rely on that number.
Because it is there. When you request it, if it is requested by portal, we provide.
How do we know that OB is not about a stolen chicken?
That is your assumption.
No, it's not an assumption.
It is there.
Anyway, you talk about 1,500 people, right?
Yes.
How did you know the 1,500? Your number, not mine. How did you know the 1,500?
I know. How to.
Do you have a list of? Do you have a list of?
You know,
estimation.
It was my estimation.
You want to help you, right? So you estimate.
It was my estimation.
Will be macho.
It's my estimation.
So since you have 1,500 people, do you have a list of the 1,500 people? Because that is a number. For you to come up with a number, you have to have a list of names, right?
Yes.
So you are saying these are part of the 1,500, according to you.
Yes, yes.
Is there evidence to show that there were 1,500?
Yes.
Where is it evidence?
The footage.
Point me to the evidence.
Footage will state it.
Or the footage counts, eh?
Yes.
1,500. So we're waiting for the footage. Secondly, you talk about a vehicle, two vehicles, GKB 79-2W and GK 83-7V, Land Cruisers, right? You say they threw stones which destroyed the vehicles, the mirror, right?
Yes.
So all of these people, you collected one stone and stoned the entire vehicle. Because you're saying respondents, meaning all 58 of them. No, it is your statement. I'm reading your statement.
They were jointly with others.
So all of them threw a stone.
Have
Have you showed the court how they hit that car or those cars?
I will provide the photograph.
You will provide. So it is you telling us what you will do. Okay. How many people can carry one stone by the?
You can carry on 10 stones.
I'm saying how many can carry one stone? According to you, after they were dispersed, you're just from telling us, they moved in different directions.
Yes.
Let me point you to number 9. Read for the court. That the respondents upon being dispersed then proceeded to MATIANG'I supermarket. So which is which? Different directions or MATIANG'I supermarket?
Those who are arrested proceeded to MATIANG'I supermarket.
No. You have said.
Those who are never arrested
Don't be clever. You have said once they were dispersed, they moved in different directions. So my question is, what is MATIANG'I different directions? Because now
that MATIANG'I is one of the directions.
you see, once they move to different your statement, not mine.
They move to different directions.
So you don't know what
Those who
you
are arrested go to MATIANG'I.
You are not sure. Very well. So another question. You have talked about that they began looting and robbing customers. Is there any customer that is a complainant in this case?
Yes.
Have you recorded a statement?
That is what I'm.
Or you are still doing that? But they are arrested. Very well. You talk about number 13. You are doing forensic. You want to do forensic evidence, right? Because you have experts.
Yes.
My question to you is one. Have you collected any gadgets from them? Their phones, laptops?
Yes, I have.
Their phones?
Yes.
Where is the inventory of the same? Is it in court?
I have it.
Where is it? That is my question.
I can't attach it to an affidavit.
Where is it? Does the court have the same?
I will provide it.
Who said you can attach it?
Supposed to attach
The time has not come to attach it.
Who says the time has not come?
any letter to DCI for forensics. Written any letter to DCI
Any letter to DCI
to conduct.
to conduct the forensics? Have you written a letter to DCI?
Yes.
You have written. Where's the letter?
Cannot be attached to an affidavit.
Why? How do we know you're doing forensic?
That is part of my investigations, and that is why I'm.
This is part of my work. I'm asking. This is because if anyone loses a phone, how do we follow up? Without an inventory, without a letter to DCI. As I finish, you talk about there are flight risks, right?
Yes.
Have you showed the court how or why there are flight risks? And before that, has anyone here before court ever been charged with an offense? Do you have a record of any of them? Do you have previous records?
Just take their fingerprints.
So you don't know, but according to the flight list, you have judged them through the eyes. No further questions, Your Honor.
Here are just two questions for the suspect.
You are who for the record?
Mishuki. Yes, Inspector.
Yes.
Those are some quick questions, they're simple. You have placed before this court your affidavit, in which you say you are the investigating officer. You did not arrest any of these people.
No.
No, you did not. And you made allegations about where they were arrested, where they were rounded up. You have an affidavit of any of the arresting officers to attest to that.
I have their statements.
I'm asking, do you have an affidavit?
I have their statements.
Are those statements annexed to your affidavit? It's a simple yes or no, are they annexed or
They are not.
They are not, thank you. Move on. A distance of, let's say, 500 meters. Yes?
No.
Physical evidence is within these 500 meters? Okay. Where is this other evidence if it's not within these 500 meters?
That one I cannot disclose.
Which leads me to the question. Since the 7th of July, what evidence have you collected?
It is only one night, so I could not
Today is the night.
more evidence as I require. That is the reason why I've come here.
Have you collected anything?
I have evidence. I have evidence.
Have you annexed them? Have you referred to them?
After that, I have evidence which I will have.
Unknown?
They are known.
Innumerable?
They are known.
Lastly, the last two questions. You say that you need time to collect the CCTV from MATIANG'I supermarket and to do the audit report come inventory, yes? That is the remaining part of the investigation.
No.
But this is the one invited to the court.
Yes.
So, these 53 suspects, can they in any way, have you indicated that affidavit, in any way interfere with your collection of that CCTV, audit report, or inventory?
Yes, I have indicated.
Where? Show me the paragraph.
In my affidavit, I've stated that it is in the interest of justice and fairness that the Honorable Court grants the custodial orders so to enable the applicants to conclude investigations without interference or obstruction.
Your take? So do you disclose in what way they would interfere or obstruct the investigation?
They can interfere in many.
Have you indicated in your affidavit? Don't speculate. Inspector, just say, have you indicated it in your affidavit? If not, we
They
don't.
can interfere with witnesses.
Tumaliza hii maneno leo.
They can interfere with witnesses before.
Have you indicated that in your
The
affidavit?
appearance means that.
Lastly, Mr. Inspector, with regards to this person having no known abuse, yes? You have seen that?
Yes.
you indicated the names of these people. Where did you get this information? You indicated first to 59 to 58 are Victor Munyao, Cilicia, and the others. You indicated their names. Yes. Where did you get this information?
About what?
About their names. Where did you get their names?
They gave me the names.
They gave you their names. And you saw the identification, I am sure, to confirm those were their names.
So far noted, I will confirm. That is the reason why.
You did not take the IDs.
I have not taken their fingerprints. That is what I'm saying.
But you take the IDs to confirm their names.
Somebody can collect ID from the street.
What you did. Just
I
so no.
Their fingerprints will tell me their names.
I do not want that. Stop putting the cat in. Okay. Just answer. Did you take the IDs to confirm their names?
Most of them had no IDs.
Okay, but once you did, you took the IDs?
Yes, I do.
At the back of that ID, it's indicated where these people come from. Is it not?
Most of them do not have ID cards.
No, the ones you took, is it indicated where they come from?
The ID cards are indicated where people
So you are therefore giving false information when you say you don't know they are false. Is it not true? It tells you the location, sub-location.
That is your assumption.
That is your second paper.
Your Honor, that's all in cross-exam.
Inspector, do you have information of where exactly these suspects reside?
No, Your Honor.
Repeat the question for the record.
I repeat for the sake of the court, do you have information of exactly where the suspects who are before court reside? Not where they live, but where they reside?
I don't know.
Do you have any information whatsoever of what they do for their living and where they work?
No, Your Honor.
Have you completed your investigations on their age and their exact and correct names?
No, Your Honor.
That's all the from the witness. Your Honor, the submission. Is that under Article 49(1)(g), the Constitution foresees three possibilities in as far as an arrested person is concerned. The first possibility is where they are charged. The second possibility is where reasons are given for the continued detention. And the third possibility is where a suspect is released on reasonable bond terms or such as other conditions are as necessary to the court. Then in the celebrated case of Oscar Subi, which I am sure has been quoted before this court, Justice Joy Ngudi stated that whereas it is undesirable for the freedoms and liberties of citizens to be curtailed by the state. Where exceptional circumstances exist, which form the bedrock of compelling reasons why a suspect or suspects in this case should continue to be detained without being formally charged. The learned judge will find that such orders should be granted once it is established that the state is acting in good faith and that the three-pronged interest that is the interest, public interest, public order and security. The interest to uphold the sanctity of the administration of justice, and also those are the events of the 7th day of July this year. As such that there was massive looting and destruction of property in other parts of the country. It is therefore our prayer that since the suspects were arrested allegedly in the course of committing the offense of looting within a supermarket, after allegedly committing other offenses in the course of the day, Your Honor, those circumstances were so exceptional that it was impossible for police officers to watch these offenses being committed and allow the offenders to walk away, to allow for investigations and arrest later on. In practice, investigating officers arrest after investigations. But the gravity of the offenses and the manner in which these offenses were being committed on the material debt necessitated that the suspects be arrested immediately, presented before court, and investigations to follow thereafter. Your Honor, in conclusion, it is therefore our prayer that whereas several of our precedents and jurisprudence in the country does not take pre-charge detention, this is a unique circumstance. That calls for the court to grant the state the fair suit.
It's easy as maybe I'm just doing preliminary.
To ensure that the right to property, the sanctity of life, and the need to preserve the integrity of the administration of justice is upheld. We therefore pray for the suspects to be detained as claimed by the investigating officer. Thank you, Your Honor.
Counsel, you had said you are cross-examining without any submissions.
If the record captured that way, then
Yes, that is what you.
I did not assert that.
Are you
We have to, if the record captures that, then we can
Yes,
strike it out of the
we
record.
there.
We have to strike that out.
When counsel said
The IO.
yes.
Yes,
during
I was
the
opposed to the line
cross-exam,
of him submitting on grounds that
she
were not.
asked you whether you were going to submit or cross-examine.
Your Honor, if my memory serves me right, when he made allegations on factual issues that were not on the ground.
Instead of all this, which is a considerable consumption of time, yes, you can clarify then.
Oh, very well.
I wanted a clarification on whether the counsel should be allowed to first cross-examine and then later on submit, or we should submit first and then later on cross-examine. So his right to submission was not.
Okay, but let it not take 20 minutes of the court's time.
Your Honor,
Briefly.
I'll take 5, I think we'll allocate each other 5 minutes, so that will come to 30 minutes. Very well, Your Honor.
No, not 30 minutes, the court's time, not your time. We have other accused persons waiting for justice.
Very well. Your Honor, I'd refer this court to Article 21(1) of the Constitution, which gives this honorable court the fundamental duty of the state and every organ to observe, respect, promote, and fulfill the rights and fundamental freedoms in the Bill of Rights. So all actors, be it the court, be it the ODPP under Article 157, and even advocates under Section 456 of the Law Society of Kenya Act, we are enshrined or enjoined by the Constitution to act in that manner. Your Honor, it is unfortunate that the proceedings and the application before you has been brought under circumstances which I'll shortly demonstrate that are in clear violation of fundamental rights and freedom of the suspects. Very important and preliminary, Your Honor, is the provision under Article 49(1)(f), which provides an arrested person the right to be presented before a court as soon as reasonable, but not later than, Your Honor, 24 hours after being arrested. Your Honor, the prosecution has craftily averred that they placed the suspects in their custody at around 2000 hours on 7. Your Honor, even if we were to go by their submissions, which we oppose and strongly deny, because most of these suspects were arrested way before that time and have spent more than 36 hours behind custody. Your Honor, that article enjoins not 24 after 24 hours, it is within 24 hours. And they have not endeavored absolutely to give any reason whatsoever or any circumstances that will have prompted for them to invoke Article 49 1F2. That is why they should have, why they brought them after the 24 hours. So that is a clear violation. Your Honor, that is important for us by dint of Article 25A of the Constitution, which provides for human dignity. Your Honor, we can argue all we want, but one of the fundamental freedoms, Your Honor, is the right to be treated in a humane way, not in a degrading manner, and not to be punished. Your Honor, most of the suspects here in contravention of the same have been inhumanly treated. They have been punished. Some of them are limping. Some of them are injured. And Your Honor, very unfortunately, they are malnourished and famished. They have not eaten. Your Honor, in fact, with the indulgence of the court, we will be seeking, because we have well-wishers who brought some bread and milk, if they could be served the same, Your Honor. From the face, you could see. Your Honor, Article 43(2) also provides for the right of any person to be accorded medical treatment. Your Honor, some of the suspects before you have been injured. Some of them, their eyes are red because of the injuries. They have bloodshot eyes, which indeed needs immediate emergency medical treatment. And as such, none has been accorded within the 24 hours, after the 24 hours, and they are better off at their homes, where they can now personally secure and guarantee their rights. Your Honor, 2 points before I conclude. The application before you, my colleagues will clearly demonstrate, is a frivolous application. Your Honor, the DPP is entrusted under Article 157(11) to act in a manner that promotes public interest. Further, Your Honor, Section 4 of the ODPP Act, the DPP should act in a manner that promotes public confidence. The manner in which the arrests have been conducted, the treatment of the suspect while in custody, their continuous detention without trial, does not in any way promote public interest or instill public confidence in the prosecution. Your Honor, we are saddened that the IO who has taken the dock did not even take time to ascertain the age of these suspects. Your Honor, Section 8 of the Children's Act enjoins each party to act in a manner that promotes the best interest of children. So even seeking 10 days to continue holding a child who has parents reveals and clearly shows the malice behind this application, the misuse of custodial applications, which will be extrapolated by my colleague. And Your Honor, we will be urging you in our submission that for the case of the children, let them be released unconditionally to their parents. But for the rest of the suspects, Your Honor, let them be released unconditionally or on personal bonds. Your Honor, I'll invite Ms. Wanjira to proceed. Submission.
Good afternoon, Your Honor. For the record, my name is Wanjira Mama. Your Honor, a lot has been said to you this afternoon, but it is important to note that the prosecution has conveniently omitted the fact that there is no holding charge to continue holding the respondents. The application, you have been told, is premised on Article 49, 1 specifically, F, G, and H, I believe. To quote Justice Kimaru in Michael Rotich versus the Republic, the citation, which is 2016 EKLR, Justice Kimaru came to the conclusion that the proper and constitutional meaning of being informed for detention continuing as you're being sought by the prosecution, the proper constitutional meaning of that phrase and of Article 49 is for there to be presented a holding charge. The only thing you have been brought, or the only thing you have been presented to, Your Honor, is just a narrative based solely on the word of the inspector that there are offenses correctly known and contemplated in law, but these do not amount to holding charges. In the alternative, Your Honor, you have been told that there are compelling reasons to continue holding them. So there is no holding charge, but there are compelling reasons. In regards to the compelling reason, Your Honor, it takes us to Section 36 again, on which this application is premised. When looking at compelling circumstances, Your Honor, you should be looking at the nature of the offense, the general nature of the evidence tabled before you, the inquiries that have been made by the police, and the reasons that necessitate the continued holding of the respondents. I think everybody here has heard the police inspector speak in a futuristic sense. I will record, I will present, I will annex, I will disclose, I will attach, I will audit. But he has brought you nothing. Your Honor, he has not presented you with names of complainants. He has not presented you with OB numbers. He has not presented you with photographs of allegedly damaged vehicles. He has brought you nothing. Your Honor, the only compelling material you have been tabled or you have been presented with is just a word of the inspector, nothing else. This obviously, speaking from his hollow affidavit, just the strength of his word, nothing else. You are supposed to waive this respondent's right to liberty and presumption of innocence. Just his word alone. A question has been posited, I think, by the prosecution, whether the inspector knows where the respondents live. And because the inspector has done absolutely nothing by way of investigations, then the respondents cannot be released. But that is not the legislative path that has been set before you, Your Honor, under Section 36 of the CPC. Again, that premises, or that, that this application is premised on. In considering whether to release the respondents, Section 36A, subsection 4, obliges this court to look at three things and three things only. Number one, the need to safeguard investigations by ensuring non-interference of witnesses. As we speak, Your Honor, you have not been given any names of witnesses. You have not been given copies of their complaints. You have not been given OBs. You have not been given anything. Therefore, it is logical and I would say maybe even common sense, to conclude that there are no complainants at this stage, because none of the names have been brought before you. It is said that the respondents were looting and even beating the people that work at MATIANG'I supermarket. You have not been given any names of injured persons that work at MATIANG'I supermarket. So even if they were to come on as witnesses for the prosecution and even for the investigator, those names have not been brought before you. So there are no witnesses to be interfered with at this moment, Your Honor.
Just summarize here.
In closing, two other things need to be considered by this court: whether the respondents are available to facilitate investigations, and whether they can appear at the specified place that is named by this court. Your Honor, the respondents are able and willing to present themselves at Kibi or at Juja police station if the court obliges it. And therefore it should not be a reason that the fact that the inspector does not know where they live is not enough reason to prevent them from being released by this court today. My able co-counsels will demonstrate other things, but it is clear that this is simply a good example of police overreach and the weaponization of the criminal justice system against its respondents. Thank you, Your Honor.
Good afternoon, Your Honor.
Let's proceed.
Your Honor, on the notice of motion, paragraph 5, we are being told that the respondents resulted in widespread destruction of property. Widespread. Your Honor, you know that the standard of proof in any criminal matter should be proof beyond reasonable doubt and not proof on a balance of probability. And therefore, Your Honor, when we talk of widespread destruction of property, it means that the rule of specificity is not observed. Then they further go and tell you that there's looting of private property, and then they don't provide evidence to that as at today, as at now. And they talk of that the respondents will pose a serious threat to public safety and national security. Your Honor, I will draw you to a case of R versus Richard David Aldens. That is the High Court, at the High Court of Nairobi, criminal case number 48 of 2016, where the court denied a claim that an accused should be detained because the case was highly publicized, and therefore releasing the accused would cause a breach of peace and public order. Your Honor, the court held that the prosecution's claims were speculative and that it had not provided evidence demonstrating the unlikelihood of arrests. So therefore, Your Honor, in addition to that, there were no complaints made from the public. I draw you to your brother, Justice Wasami, as he then was, in R versus Munir Haron Ismail. That is criminal division number 51 of 2009. And he said clearly, Your Honor, that the basic denominator is to secure attendance of the accused, in our case, the suspects, to answer to charges against him. Your Honor, in paragraph 6 of the notice of motion, we are told that during the arrests of the respondents, several items were recovered as exhibits. And Your Honor, clearly, they've not shown. We don't have the exhibits before you. We don't have an inventory before you. Even photographs, Your Honor, we don't have. So these are just mere statements of puff or mere averments. In paragraph 7, Your Honor, of the notice of motion, we are being told about the seriousness of the offense. Your Honor, that owing to the seriousness of the offenses, the risk to public security and national security implications. Your Honor, the suspects you are seeing before you, vis-a-vis the police, Your Honor, the state has monopoly of violence and has all the tools of violence. Your Honor, if you see in some of the videos on social media, how the state, how the police is executing the young ladies, the future of this nation, and men, young ladies and men, Your Honor, your heart will bleed. And if they are doing that to the unarmed civilians, what about those who will go to the police station armed? They can bomb them, Your Honor. Paragraph 8 of the notice of motion, Your Honor, we are being told about the complexity of the investigations, and that this includes recording of witness statements. If I had my brother, the inspector, he stated clearly that the witnesses went to the station and at the same time he is yet to record their statements. And Your Honor, the suspects before you have been held beyond 24 hours from 7th to 9th. So therefore, Your Honor, when you look at the cases that are presented before you that they will be charged with, that robbery with violence, and you slightly go deeper into the elements of these charges, robbery with violence, you see, and he agreed that he did say that he found the suspects in flagrante delicto, red-handed. So that means that, Your Honor, if he was to carry out forensic analysis of what? If you look at the elements of that crime, which entails that they are found in a group, found with weapons, they must have been violent, and the element of robbery established. So you are being told that they need more time to carry out forensic analysis, Your Honor. Another case is the assault of a police officer, Your Honor, and we are not told of the OB number of the said case, not here as we speak, and at the same time, the names of these officers, not told. And Your Honor, we are also not told of any P3 form that has been filled. Then, Your Honor, as I finish, when I come to paragraph 6 of the affidavit, Your Honor, paragraph 5, sorry, that at the time of the arrest, the respondents were duly informed of the reasons of their arrest, which is good enough. And Your Honor, by the time you are being informed of the reason of your arrest, it means that the IO is ready to charge you. So which means that the investigation is complete, and therefore charge. But it comes before you, Your Honor, persuade the court that I've arrested the suspects, give me more time, I've even held them beyond the 24-hour rule, I still need 10 more days so that I can continue investigating. By the time they were informing them, the natural laws of justice dictates that you arrest, you investigate, then you arrest. Not arrest, then investigate. Paragraph 6, Your Honor, I'm almost finishing. Paragraph 6, you are told that the respondents herein are believed to be part of a group of approximately 1,500 individuals. Believed to be part of a demonstration turned violent outside Georgia Police Station. Your Honor, this is hearsay evidence which is not and should not be admitted in this competent court. And Your Honor, the IO did not tell us that he's an expert in matters statistics or mathematics. That when he looks at a video, he knows that these are 1,500 people. Even myself, Your Honor, a certified actuary, I've been scored first class honors, which is mathematics, pure mathematics. Your Honor, I cannot look at a video and say, these are even 40 people, leave alone 1,500. As I finish, Your Honor, paragraph 17 of the affidavit. You are being told, Your Honor, that the respondents pose a high flight risk. And I will draw you Your Honor, we are being told that the respondents are a high flight risk. And there is no evidence given. He just says that we do not know where they are coming from. Your Honor, they do not have to know where they come from or where they stay, so long as the respondents attend court religiously and spiritedly. And Your Honor, be that as it may, the respondents have identification documents which they can leave before you, Your Honor, where they can be found, and that can help you, can help the IO, to trace them. And Your Honor, these are not foreigners, these are Kenyans, law-abiding Kenyans who are enjoying their rights to demonstrate. Your Honor, you are also being told that the seriousness of the offenses, and that I will give you the case of Richard, again, R versus Richard David Alden. And it was stated clearly that even a capital offense does not constitute a compelling reason. Even a capital offense does not constitute a compelling reason. And in the case for flight risk, Your Honor, I just give you that case, I'm sorry. In Job Kenyanya Musini versus the Republic versus Job Kenyanya Musoni, High Court at Nairobi, criminal application number 399 of 2012. The court allowed a bail application and held that mere allegations that the accused was a flight risk did not suffice. The prosecution ought to have substantiated its claims, and there is no proof that they even have passports. So therefore, Your Honor, as I finish, the definition of compelling reason as per the Thesaurus and Oxford Dictionary is that it has to be something so grieving so strong, so convincing, and so undeniable. Hence, Your Honor, Article 49(1)H states that an arrested person has a right to be released on bail or bond unless there are compelling reasons. Yet the reasons that were being given by the prosecution are uncompelling, frivolous, and fickle. Therefore, Your Honor, Article 37 protects the respondents to enjoy their right to peaceably demonstrate, picket, and present petitions. And further, Article 21, I don't know if you lost me on.
The summarize, Counsel.
Article 21 further states that it is a fundamental duty of state and every state organ to observe, respect, protect, promote, and fulfill the rights and fundamental freedoms in the Bill of Rights. And therefore, the respondents should enjoy their right to liberty, which is enshrined in the Constitution, and not granting them the bail, Your Honor, is infringing on their right to liberty and may amount to miscarriage of justice. Rest my case.
Then I will be brief. Your Honor, it is our humble submissions that
You are?
not deemed, sorry,
You are?
not deemed. It is our humble submissions, Your Honor, that an affidavit is used to adduce credible, the word here is credible evidence. What you have before you are averments, for lack of a better word, narrations of how the IO sees things. We have not seen any annexes, any statements, any letter to the DCI, or anything, or a photo to show what exactly he is deponing. Your Honor, in the affidavit we are told that the respondents were arrested due to robbery with violence. I would like the court to take judicial notice of the fact that there is a present circulating video where the respondent, that is number 36 and 37, were seen rescuing a short man. And by short, I don't mean mfupi. I mean someone who was shot. And in the course of trying to rescue the person to offer first aid, where respondent number 37 is a certified first aid personnel with a certificate, they were arrested and Bangladesh police station. That is to show you that the affidavit is full of falsehoods and claims of robbery with violence, so as to try and attach the offenses on the said respondent's part. Your Honor, further, due to the lack of any exhibits, statements, and credible evidence, the affidavit before you cannot be used to charge the same without the depiction of what they try to show. The said respondents who were told have no abode, there is nothing to prove that they have any previous records or that they are.
Councils
I am
for
finishing.
saving the
I am finishing. I am
don't
finishing.
cover ground
I am
previously
finishing.
covered by.
This one has not been covered. You will see it. There is no mention of any of the respondents having been charged of any other offense, and the assumption that their flight risk has also not been proved. The issue of abandonment alone cannot mean their flight risk, Your Honor. I end by saying, Your Honor, that you have been invited to a fishing expedition, which I pray that this honorable court does not entertain the circus that will, at the end of the day, prejudice the Kenyans right before you, whose only crime was to participate in a demonstration that the Constitution allows them. Thank you.
No, that will be all.
Yeah, just in a brief rejoinder to what my learned colleagues have stated before this honorable court, Your Honor, the state will simply say that our application is well grounded in law. It is said articles of the Constitution that have been enlisted in the said notice of motion, and the averments that have been stated by the investigating officer, DCI, Inspector Bondo, who is in court today, and has adduced several reasons as to why the state is well grounded in law and merited in seeking the pre-charge detention orders, that is a period of 10 days, for the suspect's hearing to be housed at Kibiti Police Station, for the investigations to be finalized due to the complexity of the matter, the compelling reasons that have been stated by the investigating officer, and several others that have been listed in an application that I'm sure the court will have an opportunity to read. And just to finish up, we shall simply draw the court's attention to the celebrated case of Oscar Sudi, where the tests to be applied in whether to grant orders of pretrial detention, what the court requires to look at, and considerations that are to be made. In this very celebrated case of Oscar Sudi, we also have the case of Michael Butich, where it was clearly stated what tests need to be applied. And that is that whatever application is brought to court seeking pretrial detention orders needs to be merited. We need to demonstrate that in granting those particular orders that the state or the court that grants the state order will balance the rights of the respondents hearing vis-a-vis the rights of the victims, in whom we have the complaints that have been lodged at Juja Police Station, several other issues, the exhibits and the evidence that are to be adduced. And that is why we are in this court seeking orders 10 days. Upon the completion of 10 days or even before, the state would have collated all the evidence that is going to be relied upon. And I'm sure we are going to convince this honorable court, and we have convinced it through the same application that is merited, and we are aware and hopeful that the 10 days will be granted to the state. We shall supply the authorities that the state relies upon for the court's consideration. That is all.
No, counsel.
This is totally unrelated to that. We have had 3 children in the suspects. We just like to know if this court would perhaps give us directions on how.
The court will give you concrete and Yes, general direction.
And the issue of the snacks, if I look at it, they're
That's
very,
what the court
they're very.
is the head of the children's court. Are we together?
No, I'm saying
It's court.
yes.
That is not for the court, that is for you, and we take a recess.
Oh, very well.
required in not more than 60 calendar days from the time of reading the prayer to table its report in the Senate for consideration. The Senate shall thereafter consider and adopt the report of the committee. I thank you. Next order. I have another petition to present. I hereby report to the Senate that a petition has been submitted through the clerk by Mr. Titus Thukunjoroge concerning the alleged dismissal by the African Inland Church of Kenya and payment of arrears. As you are aware, under Article 119(1) of the Constitution, and I quote, every person has the right to petition Parliament to consider any matter within its authority, including enacting, amending, or repealing any legislation. Honorable Senators, the salient issues raised in the petition are as follows. 1, that Mr. Titus Thukunjoroge was employed by AIC Kenya through a signed contract between himself and the Central Church Council Bishop, who endorsed and confirmed his position as permanent and pensionable. That although his permanent employment status entitled him to a house and traveling allowances, Mr. Njoroge did not receive those benefits throughout his service. That from October 2024 to April 2025, Mr. Titus Thukunjoroge did not receive his salary and allowances despite undertaking his duties. Upon raising the issue with his employer, he was informed that he had been employed on contract terms for a period of 2 years and that he had been replaced by another employee without prior notification or due process. That the petitioner made several attempts to resolve the concerns presented in this petition with his employer, the Minister of Labor and Social Protection, State Department for Labor and Skill Development Department, all of which have been unsuccessful. That none of the issues raised in the petition are pending before any court of law, constitutional, or legal body. Consequently, the petitioner prays that the Senate intervenes in the matter with a view to do the following. 1, making recommendations on compensations to Mr. Njoroge, and 2, making any other recommendation necessary in the circumstances. Honorable Senators, pursuant to Standing Order 238(1), the petition is hereby committed to the Standing Committee on Labor and Social Welfare for consideration. And in terms of Standing Order 238(2), the committee is required in not more than 60 calendar days from the time of reading this prayer, table its report to the Senate for consideration. I thank you. Next order.
Order number 5, papers.
The Senate Majority Leader.
Mr. Speaker, I beg to lay the following papers on the table of the Senate today, 9th of July 2025. The annual report of the Parliamentary Service Commission for financial year 2023-2024, the graphic health warnings for tobacco products, legal notice number 1 of 7 of 2025, the county government's budget implementation review report for the first 6 months for financial year 2024-2025, biannual report of the Commission on Administrative Justice for period July to December 2024, and the County Licensing Uniform Procedures Regulation, legal notice number 91 of 2024. Mr. Speaker, I beg to lay.
Chairperson, Standing Committee on Health.
Okay. Yes. And you are the vice chair.
I thought you were vice chair. Okay, let me do it on behalf of the Health Committee. Mr. Speaker, I beg to lay the following paper on the table of the Senate. Today, the 9th of July 2025, this is a report of the Standing Committee on Health on its consideration of Community Health Promoters Bill, National Assembly Bill number 53 of 2022. On behalf of the Chairperson, Standing Committee on Health.
The Chairperson, Standing Committee on Trade, Industrialization and Tourism.
Yes. Mr. Speaker, sir, I beg to lay the following paper on the table of the Senate today, 9th of July 2025. The report of the Standing Committee on Trade, Industrialization and Tourism on its consideration of the Startup Bill, that is Senate Bills number 14 of 2022. On behalf of the Chair, Standing Committee on Trade, Industrialization and Tourism. Thank you.
The Chairperson, Standing Committee on Labor and Social Welfare.
The report on petition concerning the failure by Kenya Breweries Limited, Kaplan and Stratton Advocates and Harrison Kinyanjui.
Senator Murgo, when you're laying a paper on the table, you need to be at the dispatch.
Mr. Speaker, sir, I beg to lay the following papers on the table of the Senate today, 9th July 2025. So I beg to lay.
What exactly are you laying, Senator Murgo?
Report on the Standing Committee on Labor and Social Welfare on its consideration of reports, amendment number 2, Bill, Senate Bill number 45 of 2024, report on the Standing Committee on Labor and Social Welfare on petition to the Senate by Mr. Lawrence Ndutu on behalf of 125 other former employees of Kenya Breweries Limited concerning failure by the Kenya Breweries Limited, Kaplan and Stratton Advocates and Harrison Kinyanjui Advocates to pay compensation awarded to the petitioners. I beg to lay.
Senator Catherine Muma. That is dropped. Senator Jackson Mandago. That also is dropped. Next order.
Order number 6, notices of motion.
The Chairperson, Standing Committee on Labor and Social Welfare.
Mr. Speaker, sir, I beg to give notice of the following motion that the Senate adopts the report on Standing Committee on Labor and Social Welfare on petition to the Senate by Mr. Lawrence Ndutu on behalf of 125 other former employees of Kenya Breweries Limited concerning the failure by the Kenya Breweries Limited, Kaplan and Stratton Advocates, and Harrison Kinyanjui Advocates to pay compensation awarded to the petitioners laid on the table of Senate on Wednesday, 9th July 2025. So I beg to lay.
Senator Richard Onyonka. The business is dropped. Senator Karen Nyamu. The business is dropped. Senator Catherine Muma. The business is dropped. Senator Jackson Mandago. The business is dropped. Next order.
Order number 7, questions and statements.
Statement pursuant to Standing Order 53-1. Senator for Kitui County, the Honorable Enoch Wumboa.
I thank you, the Speaker. I rise pursuant to Standing Order 53-1 to seek a statement from the Standing Committee on Education on a matter of county-wide concern regarding the welfare of teachers serving in ASAL and other hard-to-serve areas in Kitui County. Mr. Speaker, sir, Kitui County is predominantly an arid region. However, a significant number of teachers in the county do not benefit from the special allowances and considerations provided by the Teacher Service Commission for those serving in the arid and semi-arid lands and other hard-to-serve areas. In the statement, the committee should address the following. 1, which wards in Kitui County are designated by the government as ASAL and hard-to-serve areas? 2, the criteria used by the government to designate areas as ASAL and hard-to-serve areas. The number of teachers in Kitui County currently benefiting from the ASAL and hard-to-serve areas allowance scheme, and the number of those who don't benefit from this scheme. And finally, the plans in place by the Teacher Service Commission to ensure that all deserving teachers in Kitui County benefit from the arid and semi-arid lands and hard-to-serve allowance scheme. I thank you, Mr. Speaker.
Senator for Samburu County, the Honorable Dr. Lelegwe. That statement is dropped. The Senator from Busia County, the Honorable Omtata.
Mr. Speaker, sir, thank you for the opportunity. I rise pursuant to Standing Order 53(1) to seek a statement from the Standing Committee on Tourism, Trade and Industrialization on a matter of national concern regarding the move by the government to grant the Business Bay Square Mall in Eastleigh approval to import 500,000 metric tons of rice into the country. Mr. Speaker, sir, this development has raised concern about the impact of this decision on local rice farmers, the transparency of the quota allocation process, and the apparent bypassing of established regulatory institutions such as the Agriculture and Food Authority, brackets AFA, which, under the Crops Act, is mandated to oversee decisions related to food crop imports. In the statement, the committee should address the following. 1, the criteria and policy justification used by the government to allocate the rice importation quota to Business Bay Square Mall, including whether the process was competitive and aligned with legal and regulatory frameworks such as the Crops Act and the Food Crops Regulations of 2019. 2, the role played by the Ministry of Trade in this importation and why the Ministry of Agriculture and the Agriculture and Food Authority, brackets AFA, were not consulted in a matter that falls under their regulatory mandate. 3, assessment by AFA on the current domestic production and consumption levels of rice and whether a deficit existed to warrant this large-scale importation, especially in light of reports indicating that more than 5,000 metric tons of rice remain uncollected at the Mwea Rice Growers Multipurpose Cooperative Society. The measures in place to cushion local rice farmers from the adverse effects of such imports, including the budgetary provisions referred to by the Director General of AFA to procure excess rice from local cooperatives, and how this aligns with Kenya's agricultural policy priorities under the bottom-up economic transformation agenda, in brackets, better. 5, impact of rice imports on local market prices and outline strategies being implemented to balance food affordability for consumers while safeguarding the competitiveness and sustainability of local rice production. Thank you, Mr. Speaker, sir.
Senator for Kisumu County, the Honorable Professor Tomo Janda.
Thank you, Mr. Speaker. Mr. Speaker, I rise pursuant to Standing Order 53-1 to seek a statement from the Standing Committee on Roads, Transportation and Housing on a matter of county-wide concern regarding the demolitions that are being carried out in Korando, Tiengre, and other parts of Kisumu County, allegedly to pave way for road expansion. In the statement, Mr. Speaker, this committee should address the following. 1, the legal authority under which the ongoing demolitions in Korando, Tiengre, and other areas of Kisumu County are being conducted. 2, whether the affected residents were issued any form of notice before the demolitions and whether there was any public participation or stakeholder engagement in accordance with the Constitution and relevant legal frameworks. 3, the status of land on which the demolitions are taking place, specifically whether the affected properties are situated in public, private, or community land. 4, the existence of any compensation or resettlement plans for residents whose homes or properties have been demolished. And lastly, the entities or agencies involved in executing the demolitions and whether they are acting under formal directive or legal mandate. Mr. Speaker, my second statement is on the state of facilities in health facilities in Kisumu County. Mr. Speaker, I rise pursuant to Standing Order 53-1 to seek a statement from the Standing Committee on Health on a matter of county-wide concern regarding the state of health facilities in Kisumu County. In the statement, the committee should, 1, address the state of all public health facilities in Kisumu County, including their level of functionality, staffing, and service availability. 2, whether there are any stalled projects, including those under construction or renovation, stating the reasons for the delays and plans in place to equip these facilities. 3, the efforts by the county government of Kisumu to improve healthcare infrastructure and staffing and to ensure the availability of essential medicines, laboratory services, and emergency care in major county hospitals and health centers. And lastly, where the county government has entered into any partnerships with any development partners to strengthen the county's health system. Mr. Speaker, my third statement is on the role of county governments in national economic planning. Mr. Speaker, these are statements requested under Standing Order 53-1 from the Standing Committee on Finance and Budget on a matter of national concern regarding the role of county governments in the formulation and implementation of national economic planning framework. In the statement, the committee should address the following. 1, the framework currently in place to ensure that county integrated development plans, CIDPs, inform and or align with the national government's medium-term plan, the MTP, and overall development priorities outlined in the bottom-up economic transformation agenda, BETTER, and Vision 2030 in general. 2, how the Intergovernmental Budget and Economic Council, IBEC, and the National Treasury and Economic Planning ensure that national government's fiscal and economic policies reflect the needs of counties. 3, whether there are plans to strengthen the existing intergovernmental frameworks to institutionalize participation of county governments in national economic policy formulation consistent with the provision of Articles 6, 10, and 174 of the Constitution, and if so, obtain information on such plans. Mr. Speaker, my last statement is on access to and quality of education in marginalized counties under the competency-based curriculum, CBC. Mr. Speaker, I rise pursuant to Standing Order 531 to seek a statement from the Standing Committee on Education on a matter of national concern, namely the implementation, access to and quality of education under the competency-based curriculum, CBC, in marginalized counties. In the statement, the committee should address the following. 1, the progress made in rolling out the curriculum-based program, CBC, in marginalized regions, including adequacy of infrastructure and the availability of learning materials tailored to CBC requirements. 2, the challenges faced by schools in marginalized counties in effectively implementing the CBC, including issues relating to teacher preparedness and community awareness. 3, the interventions by the national government and county administration to train and support teachers in delivering CBC in marginalized areas. 4, measures put in place by the State Department for basic education to ensure equitable access to CBC for all learners, with specific focus on girls, children with disabilities, and other vulnerable groups. And lastly, the strategies established to monitor and evaluate the quality and impact of CBC in marginalized counties to inform policy and guide resource allocation. I thank you, Mr. Speaker.
Senator Eddy for and on behalf of Senator Sifuna.
Mr. Speaker, thank you. I rise to request for statement on behalf of the Senator for Nairobi, Senator Edwin Sifuna. And this is a statement, a request for statement on lack of electricity access in parts of Nairobi City County. Mr. Speaker, sir, I rise pursuant to Standing Order number 53-1 to seek a statement from the Standing Committee on Energy on a matter of county-wide concern regarding the continued lack of access to electricity in various neighborhoods across Nairobi City County. Mr. Speaker, sir, several areas across Nairobi continue to suffer from power deprivation, either due to prolonged disconnection, non-existence infrastructure, or unexpected neglect. This situation has led to increased insecurity, stifled economic activity, and deepened inequality in places that include Hospital Ward in Mathare constituency, which has been without electricity for over 4 years. 2, Majengo Gorofani in Kamukunji constituency, which has been in darkness for 2.5 years, yet residents still receive Kenya Power bills. 3, Korogosho Ward in Roraka constituency, where, Mr. Speaker, the entire villages such as Gomongo, Ngunyunu, Gitathuru, Iridge, Grogon A, and Grogon B, Korogosho A, Korogosho B, and Nyayo remain unconnected. 3. Reri Gateway, Simba Cool Zone, and Bantu Zone in Kwaruben Ward of Embakasi South, which continue to live without any access to electricity. Therefore, Mr. Speaker, in this statement, the committee should address the following. The plans in place by the Kenya Power to reconnect electricity to Hospital Ward in Mathare constituency, which has been without power for 4 years. 2. The current status and timeline for reconnecting Majengo Gorofani in Kamkunji constituency, where residents have lived in darkness for 2.5 years, yet they continue to be billed. And lastly, Mr. Speaker, whether there are concrete plans by Kenya Power to connect the unserved villages in Gorogosho Ward, that is Gomongo, Ngunyunu, Gitadhuru, Highbridge, Grogan A, and Grogan B, Gorogosho A, and Gorogosho B, and Nyayo, and the areas of Reri Gateway, Simba Cool Zone, and Bantu Zone in Kwaruben Ward, Embakasi. The Senator for Nairobi, Senator Edwin Sifuna. I thank you, Mr. Speaker.
Senator Haji.
Thank you, Mr. Speaker, sir. I rise pursuant to Standing Order 52.1 to make a statement on a matter of general topical concern, namely the outstanding performance by Faith Kipyegon and Beatrice Chebet at the Eugene Diamond League 2025 Prefontaine Classic held on 5th July 2025 in Eugene, Oregon, USA. Mr. Speaker, can I be protected?
Order, honorable senators. May Senator Haji be heard in silence, please. Proceed, honorable senator.
Thank you, Mr. Speaker, sir. Mr. Speaker, sir, Faith Kipyegon's victory in athletics is rooted in humility and determination. Born on 10th January 1994 as the 8th of 9 children to a modest family in Bomet County, she ran barefoot to school and began athletics at the age of 14, after excelling in a physical education PE race, even before owning her first spikes. Her early triumphs include edging out older rivals to claim gold at both the 2011 and 2013 World Cross Country Juniors, and clinching the 1,500-meter titles at the 2011 World Youth and 2012 World Junior Championships. Mr. Speaker, sir, as a senior, her track record over the years speaks volumes. 3-time Olympic champion in the 1,500 meters, Rio 2016, Tokyo 2020, and Paris 2024. 3-time world champion, London 2017, Eugene 2022, and Budapest 2023. Diamond League champion on multiple occasions, including memorable wins in Monaco, Brussels, and Paris. And 2023 world record treble, breaking world records in 1,500 meters, 5,000 meters, and the mile within just 2 months. Mr. Speaker, sir, reflecting on her record-breaking run at the Florence Diamond League, Kipyegon spoke warmly of the role competition played, noting how her rivals stayed with her in the chase. And I quote, Mr. Speaker, sir, Senator Cherargei is making too much noise. Reflecting on her record-breaking run at the Florence Diamond League, Kipyegon spoke warmly of the role competition played, noting how her rivals stayed with her in the chase. To be honest, she says, and I quote, "To be honest, the ladies were pushing me in the race, and that is what I wanted to motivate the younger generation to come and do even better," she said, moved by the sight of competitors gathering to cheer her on as she came around for her lap of honor. During the Eugene Diamond League 2025, in the women's 1,500 meters, Faith Kipyegon delivered a phenomenal performance by clocking an astonishing time of 3 minutes, 48.68 seconds, thereby breaking her previous record of 3 minutes, 49.04 seconds set during the Paris Diamond League in July 2023. This breathtaking feat reaffirms her dominance and relentless pursuit of excellence in middle distance running. What makes this achievement even more remarkable is that it comes just 9 days after she narrowly missed becoming the first woman in history to run a mile under 4 minutes, a feat she has long pursued and which remains within her grasp. But she still managed to achieve to run the fastest mile in history by any woman. On the same evening, Mr. Speaker, sir, Beatrice Chebet demonstrated sheer brilliance and tactical mastery to claim victory in the women's 5,000 meters. This was not just a win, but a historic achievement as she broke the world record, clocking an impressive 13 minutes, 58 seconds, 58.06 seconds, shaving more than 2 seconds off the previous record set by Ethiopia's Gudaf Segei in Eugene, Oregon in 2022. This made her the first woman in history to run the 5,000 meters under 14 minutes. Chebet's performance was described as a display of sheer brilliance and tactical mastery, as she led from start to finish, maintaining a blistering pace throughout the race. Mr. Speaker, sir, Faith Kipyegon and Beatrice Chebet, two friends who embody the very best of Kenyan talent, combining discipline, resilience, and unmatched skill. Their success in Eugene, Oregon reminds us all of the immense potential that lies within our nation when talent is nurtured and supported. These two remarkable athletes have once again lifted the Kenyan flag high on the global stage. Their achievements are a testament to Kenya's enduring legacy in athletics and serves as a powerful source of inspiration for the youth across the country. Mr. Speaker, sir, on my behalf, and on behalf of the Senate and the people of Kenya, I extend a heartfelt congratulations to Faith Kipyegon and Beatrice Chebet for their incredible victories. We celebrate them not only as champions of the track, but as role models for the entire nation. May they continue to shine and inspire future generations as they prepare for more global competitions. I thank you.
Now, honorable senators, will come back to this order for purposes of getting comments from honorable senators. But for now, pursuant to Standing Order 45-2, allow me, for the convenience of the House, to rearrange today's order paper. We will now move to order number 8, number 9, and number 8, then number 9, and number 10. Then we come back for comments. Clerk, you may proceed to call those orders.
Order number 8, the Seeds and Plant Varieties Amendment Bill, Senate Bills number 4 of 2025, first reading. A bill for an act of Parliament to amend the Seeds and Plant Varieties Act to introduce a standards-based seed registration system to facilitate timely approval of the seeds varieties and for connected purposes.
Next order.
Order number 9, the Social Protection Bill, National Assembly Bills number 12 of 2025, second reading, division.
Sergeant at Arms, kindly ring the division bell for 1 minute. No, it's ringing. Sergeant at Arms, kindly ring the division bell for further 3 minutes.
Well, the senators are about to go into division regarding the Social Protection Bill. This is a bill originating from the National Assembly. The Social Protection Bill number 12 of 2025, a bill that is co-sponsored by the Senate Majority Leader, Honorable Aaron Cheruiyot. This is a bill that is at its second reading stage, and the vote that they will be taking is that the bill be read a second time for it to be able to proceed into the next stage, that is it being considered at the Committee of the Whole. And this is a bill that seeks to reduce poverty and vulnerability and improve the well-being of people by providing assistance, services and programs that build human capital, as well as cushion people against risks and contingencies throughout their life cycles. The bill provides for the establishment of the National Board for Social Protection. You will recall that there are already a number of programs that are targeting to reduce poverty and vulnerability among the citizenry of Kenya. However, this is a bill that proposes the establishment of a National Board for Social Protection. And in that particular board, their functions and composition will be defined, the powers that they will be possessing, as well as its source of funds. Some of the functions of the board will include advising the Cabinet Secretary on matters relating to social protection, designing and implementing social protection interventions, as well as programs, also providing social assistance and social care to the vulnerable persons in the society, also coordinating social protection interventions, establishing and maintaining a social protection registry, among other mandates, as will be defined within their functions or their powers. The 3-minute division bell has ended. The House has attained the quorum for the vote to be taken. As we can see that the clerk is trying to ascertain whether the number is present. If the number is present, then they will go ahead into the division process. We shall be waiting to be guided by the House, but this is a bill that also touches on the counties and therefore has been forwarded to the Senate for consideration. Debate already took place conclusively or comprehensively on the floor of the House. So the voting is for it to be read a second time and move into the next stage. The next stage, that is where, in case the members have any amendments into the bill, then they will be able to consider those amendments, proposals, and then they will also be shared back to the National Assembly for consideration. So we shall be waiting to see if the quorum is present for the division to take place. Then that would, without any further delay, continue. This is a bill that provides for the administration of social protection benefits as well. And it also outlines the categories of persons who may be granted social protection benefits, the types of social protection benefits offered under the Act, the eligibility criteria, as well as the procedure for applying for the benefits. It also provides for the reviews and appeals against the decisions of the board, the rights and obligations of beneficiaries, the consequences of abusing social protection benefits, and the circumstances under which social protection benefits may be terminated or refunds made to the board. Also provides for the review of social protection benefits, the indexation of social protection benefits, and the establishment of a social protection registry. This is a bill that is on the floor of the Senate, a bill that seeks to reduce the poverty and vulnerability of persons in the society and improve their well-being by providing assistance, services and programs that build human capital and cushion people against risks and contingencies throughout their life cycle. There are already programs. However, in this particular bill, there is a proposal for the establishment of a national board for social protection. It will be defining the mandate that the board will be taking, its composition, and the powers and the sources of funds as well, so that as they carry out the mandate that is bestowed on them, then accountability and transparency shall be adhered to regarding that. The bill also provides for offences, and in the offences created under the bill, this bill include the prohibition of obstructions, the prohibition of persons from giving false information, as well as unlawful disclosure of information. All right, let's listen in.
Order number 9. We will move to order number 10, and thereafter maybe come back to order number 9. Clerk, proceed to call that order.
Order number 10, Committee of the Whole, the Conflict of Interest Bill, National Assembly Bills number 12 of 2023, consideration of His Excellency the President's recommendations.
Honorable Senators, it's good to be attentive. Senator Shakila.
Honorable Senators, we are in the Committee of the Whole, the Conflict of Interest Bill, National Assembly Bills number 12 of 2023. President's recommendation on clause 2, Clerk.
President's recommendation on clause 2.
I propose the question that the President's recommendation clause 2 be approved. Chairperson Jelak.
Thank you, Honorable Chairman. I wish to move that the recommendation is approved as provided for in the order paper. And generally, Mr. Chairman, this is as regards what we term as undeclared assets, which has ably been run through in the order paper.
I put the question that the President's recommendation clause 2 be approved, division at the end.
President's recommendation on clause 5.
Senator Cherargei, I've already put the question. Cherargei, I've already put the question. It is allowed, Cherargei, but you should have. Senator Cherargei, can you make your sentiments known in the next, when I put the question on the next clause? Yes.
President's recommendation on clause 5.
I propose the question that the President's recommendation clause 5 be approved. Chairperson.
Mr. Chairman, I move that the President's recommendation be approved as proposed. And specifically, Mr. Chairman, this is a definition as regards the reporting authority. And the committee indeed did approve that the reporting authority be deleted so that we retain that it is only one that the law provides, that is the Ethics and Anti-Corruption Commission.
Senator Cherargei.
Mr. Speaker, on these clauses, on the clause, can the mover sit? Mr. Speaker, can the mover sit as I speak? Is violating standing orders where you cannot see me. So, Speaker, mine is a comment on the issue of affinity. You know the definition of affinity. I have seen that relative means a person who is related to a public officer by birth, marriage, adoption, or affinity. Mr. Speaker, I think we should drop the word affinity because the definition of affinity in English language, the Oxford Dictionary, means the liking of a person. So does it mean if I've been your friend for some time and I have close affinity, then it is defined as a relative? Mr. Speaker, I find it would have been consanguinity affinity, as in closeness by blood, as my learned colleagues would define, Mr. Speaker. So I think on this memorandum, it should only stop at adoption, because the moment you add affinity, it changes meaning. It means somebody you are affinity to as a friend, be it a male or a female, or somebody you banter with, or somebody you work with. So, Mr. Speaker, I think this one is on the issue of ethics report. I think that definition should be ethics and anti-corruption. If the definition comes out as ethics only, then we can equate to the Ethics Commission, but it should be Ethics and Anti-Corruption Commission. So on the issue of affinity, Mr. Speaker, and then, Mr. Speaker, on the issue of undeclared asset, the manner that has been proposed. Mr. Speaker, let me reserve those to close number 6 so that I can make that comment at that point. So on this issue of affinity, we must drop it, Mr. Speaker, because it is unfair. It will, Mr. Speaker, in fact, in conclusion, it will undermine freedom of association as provided by the Constitution. Because affinity allows friendships. It allows acquaintances, Mr. Speaker. So if you say we cannot, if a public officer is found to have committed an economic crime, Mr. Speaker, it means those people close to him, associates, which is not properly defined by law, can run into problems, therefore undermining the principle and the freedom of association as per the Constitution. So in it is a nullity, so to speak. It's a nullity. And I hope the chairperson of JLAC is listening this keenly. It is dangerous because the moment we come for you, God forbid, for Senator Haji over an economic crime, it means friends like Cherargei can be in trouble. So, Speaker, we must drop this for the interest and for not undermining freedom of association within the setup. And we also, you know, families, Mr. Speaker, are so huge in African setup. In fact, I have many cousins that the last time I saw them was years and years. So, Mr. Speaker, that is only my worry. On the issue of undeclared assets, I will come back on clause number 6. I thank you, Mr. Speaker, for the indulgence.
Senator Mungatana.
Thank you. Is it on? Thank you, Mr. Speaker. Mr. Speaker, I am very alive to the fact that overriding a presidential memorandum is an uphill task as per the Constitution, but we must go on record so that maybe if matters go to court, the intention of the legislature can be interpreted from the record by the lawyers who will be there. And the worry here about the affinity definition, it is so wide, so that a person who wants to enforce, and here I'm looking at the ESCC, they are the enforcing authority. If they are going to define relative to mean a person who is related to the public officer by birth, by marriage, adoption, or affinity. Mr. Speaker, when you look at the first 3, there is no discussion about it. But when you come to the 4th one, affinity, it is so loose that somebody can actually use that to harm people or to just destroy somebody. It means that when they're enforcing anything against a public officer, they can go for any person, really any person, whom they think they have some form of affinity or association. This means every friend that you stay with, every person you play basketball with, any person you go to church with, even your church members, even every place, literally, the members of your social welfare group. Mr. Speaker, I think this word, there's a problem here, and the intention cannot be to expose people to this extent, and it's obviously in conflict with the freedom of association article in the Constitution, which means even if it passes here, somebody should pick it, and we go and remove this word through the courts, because this is wrong. I don't know what the thinking was here. I submit, Mr. Speaker.
Senator Osotsi.
Mr. Speaker, just like Senator Mungatana said, actually overriding a presidential referral is an uphill task, because it requires 2/3 members of this House to change that. But I think it should go on record that there is an ambiguity in this definition for a relative, particularly the word affinity. What is affinity? It's ambiguous. Mr. Speaker, you can have an affinity to many, even in this House. between you and me, we have some affinity because we are senators. So if I commit a crime, you will be arrested, Mr. Speaker, because of me. I think this word will be used for political persecution. Because, for example, we are in political parties. We are put in that political party through some affinity. So, if I commit a crime, or my party leader, or my deputy party leader, or my SG, they will come for me. So, Mr. Speaker, we must clearly indicate that as legislators, we have a problem with this word affinity. And I know at this point we can't do much about it because we need 2/3 of members of this House to override that. But it must go on record that this House was uncomfortable with the definition of the word relative. Mr. Speaker, this foreign legislation, which are forced on us, is what is creating problems in this country. Even now, we are talking about Gen Zs and all that, too much freedom. It's because we adopted a constitution that this country was not ready for. And that's why we're having problems. This piece of legislation, Mr. Speaker, is going to cause problems in this country. Because it is going to be used for political persecution, is going to be used to intimidate people. Today I will be in government, tomorrow I'm not in government. They will come for me, Mr. Speaker. So, Mr. Speaker, I want to register my disapproval of the definition of the word relative. And it should go on record that on this particular day, this House, members of this House were in agreement that this definition is vague and something has to be done. Even if the bill is passed, we must amend it to make it, remove that ambiguity, Mr. Speaker. So, Mr. Speaker, I don't support that definition.
Senator Esther Okinyuri.
Thank you, Mr. Speaker. I also wish to join my colleagues to express displeasure, especially in the definitions, lack of clear definitions, especially for family, relative, and affinity. Because, Mr. Speaker, in as much as we want to curb loopholes in the public sector, if you do not clearly state whom you're targeting here, we might end up exposing even people who are very innocent, so long as they associate with us to this proposal, Chair. So I feel as a Senate, we need to keenly look at this, either by providing an alternative way of defining who is family to you, who is a relative, and affinity, who are these who are close to you that we want to target, Chair. So if we don't clearly define those three, we might actually expose very innocent people to some of the issues we are trying to curb, Chair. Thank you.
Senator Mandago.
Thank you very much, Honorable Chair. Honorable Chair, I want to join my colleagues on this matter of definition of affinity and the general definition of a relative and family, Honorable Speaker, Chair. The definition of family here, the spouse, dependent child or parent of a public officer, a dependent child of the spouse or public officer, or a parent of the spouse of a public officer. Relative means a person who is related to a public officer by birth, marriage, adoption, or affinity. Chair, even relationship by birth should even be made very clear. Because in the African context of relationship by birth, my cousin brother, whose father is brother to my father, in the African context, is defined as being people related on one bloodline. Chair, I really don't understand what this bill wants to address. Just as Senator Cherargei said,
We have so many relatives who we are even related by blood, but we don't know what they do for their everyday living. Is this bill telling us then that we as public officers should declare all our relatives, and the government should meet their daily subsistence needs, because as soon as this bill passes, or this memorandum passes, it means those people might end up stopping what they have been doing for their daily livelihood, and they will be then dependent on the public officer. Is the government ready to provide subsistence? This thing of affinity, Chair, should actually be deleted. And we should even give a new definition. It should actually stop at an adopted, where we have adoption. This affinity is so wide that it will be open to abuse, Chair. And because some of these institutions, we cannot say they are immune to being politically weaponized, we should make our definitions very accurate. I have a problem also on the undeclared assets means and any asset that is not disclosed in the prescribed manner. Chair, if I've declared an asset and probably in the sentences I've missed one or two letters or missed this, if you go down in that bill, it means that this asset should be forfeited. I think the law should be providing an opportunity for further details, for further inquiry. But for you to just say that because you missed, probably you missed, you are declaring your land and you have said block 13/1671 instead of stroke 1617, then you forfeit that asset because you have not declared it in a prescribed manner. Chair, that will be a problem. We cannot and we should not allow this house to be used by financial institutions that want to make it difficult for Kenyans to do business, that wants to make it difficult for the economy of this country to grow so that we continue borrowing from them by passing legislations and amendments such as this, Chair. So I wanted to go on record on that, that we need as a house to look at that definition and leave the word affinity, and even the undeclared assets, what means any asset that is not disclosed, Chair, that should be dropped completely. Thank you, Chair.
Honourable Senators, yes, I see that there is a lot of interest in making comments on this clause. I'm afraid that we might, because after 5 senators have spoken, it will just be repetition. Can we go to the next clause and then we give you an opportunity? Are you going to repeat anything that has already been said? Senator Ojenda?
Chair, I know, and yes, I know that some of these amendments are extraneously driven, and the intention as expressed by Senator Mandago is we'll have the result of stifling business, stifling development, and I want senators to open their eyes. The public officers in question, Chair, are not senators or members of parliament. Contemplate a public officer as a chief or a primary school teacher with many relatives in the village. And that public officer, Chair, is supplying maize to a school or to a government office in the village. Now, Chair, most Africans do not even know who their relatives are because we have extended relatives. So that definition is problematic because at times we cannot even define who our relatives are. And then lastly, I just want to, this is with a perspective, agree with Mandago. On the undisclosed assets or named assets, either by error, perhaps negligence, or out of lack of valuation, you will lose an asset. Yeah, this is a serious thing. Senator Osothi's concern is about the threshold, but we have a problem here, Chair. The only way to make sure this does not pass is by denying ML quorum and walking out. Then now this will not pass.
Senator Professor Ojienda, I was really looking forward to your ingenious submission, which I actually missed. Senator Abbas, I hope you are not going to repeat what has already been said.
No, I'm not going to say that. Honorable Speaker, I think by nature nobody commits offense as proxy on behalf of somebody else, unless it's something somebody hired or these things. But in terms of, we have all our adults, and they carry their own crosses. So whatever your brother, you don't even know where he is, maybe he could be in the other world of the world, you could be somewhere else, it commits, then you cannot take the responsibility for it, or your relative. So I oppose the amendment.
Senator Navindu.
Okay. Thank you, Chair. And because I don't want to repeat what others have said, I'll just comment on, and Chair, I wish, ML, can I borrow the ears of the Chair, please? Chair, I will not repeat what others have said, but this amendment, the way it is, it will cause a lot of problems to many others. And I'll read a scripture in the Bible. In the book of Ezekiel, chapter 18 and verse 20, highlights that the mistakes of a father will never be condemned to a child. So this is not right. Because if anyone does wrong, they should carry their own cross, but not any relative, not any child, not any affiliation, as in the definition of affinity. This is quite wrong. It's not biblical, and it is not good for anyone. Thank you, Chair.
Thank you, Senator. Senator Mohamed Faki.
Mwenyekiti, mimi pia natoa kauli yangu kupinga kipengee hichi kwa sababu Mheshimiwa Mwenyekiti, nilinde na kamishna hapa
na kusikiza
ambaye ni senior counsel na Ojienda pia ni senior counsel. Mheshimiwa Speaker anasema kwa kipengee hichi ni kinyume na hata maadili ya Kiafrika. Kwa sababu Kiafrika tunaishi kama jamii moja. Kwa hivyo kwa mfano mimi ni senator, lakini mtoto wangu ameajiriwa na ofisi ya ODPP. Kwa hivyo yeye inawezekana kutokea shida katika ofisi yake, nilaumiwe mimi ambaye ni senator, ambaye niko kivyangu na ninafanya kazi zangu tofauti na yeye. Kwa hiyo Mheshimiwa Speaker, hii sheria yapinga maadili ya Kiafrika na vile vile ni kinyume na katiba, kwa sababu huwezi kumnyonga mtu au kumnyang'anya mali yake bila ya kumpa nafasi ya kujieleza kisheria. Kwa hivyo twapinga kipengee hichi na twaomba kiondolewe mara moja katika hiyo memorandum ambayo rais ameleta kuhusiana na hiyo sheria ya maadili. Asante Mheshimiwa Speaker.
Thank you, Senators. We shall proceed. I put the question that the President's recommendation, Clause 5, be approved, division at the end. Next.
President's recommendation on Clause 6.
I propose the question that the President's recommendation, Clause 6, be approved. Chairperson.
Thank you very much, Chairman. In the course of the committee's consideration of the recommendation or reservations under Clause 6, the committee indeed observed and agreed with the proposals that the Ethics and Anti-Corruption Commission be given the sole mandate to implement this particular act once it's passed, and the further recommendation that the committee made is in concurrence is that the reservations on this particular clause will need the strengthening of the technical and budgetary capacity and allocation to EACC in order for it to be facilitated to administer and effectively implement the provisions of this particular act. That is the impact of the committee's recommendation on the reservations under Clause 6. Thank you, Mr. Chairman.
Senator Cherage, will you be commenting on every clause? Okay, then let us also recognize that we are not debating, so you need to be brief. Please keep your comments in less than 3 minutes.
Mr. Chairperson, you know you are not also immune if this comes to law. It will disrupt our daily lives. Speaker, institute proceedings for forfeiture or undeclared or unexplained. Mr. Speaker, this recommendation is very unfortunate. Because, Mr. Speaker, we are aware, either by error or design or default, either by KRA or EACC, when they are doing inventory of your assets, they can leave it unexplained, Mr. Speaker. We are aware of cases where the authority, Mr. Speaker, I wish the two senators, Mr. Speaker, they are blocking you, yet the standing orders is very clear that there should be no one between you and the Speaker. The table office, what is happening? Senior counsel, he just chatted in. He should go and relax and recover from jet lag. So, Speaker, he should institute proceedings from forfeiture of unexplained or unexplained, and is the former chair of EACC, Mr. Speaker. Mr. Speaker, you should be listening. You should be listening, senior counsel. You know you can be old, but you don't have a brain. Mr. Speaker, what I'm saying, institute proceedings, Mr. Speaker, for forfeiture and unexplained assets. Therefore, the question should be, if it is left out, Mr. Speaker, if it is left out, either by design, these unexplained assets, Mr. Speaker, you might lose your property, Mr. Speaker. So I think this amendment, I go with the proposal by the Committee of JLAC on this particular amendment to this memorandum by His Excellency the President. I rest my case, Mr. Speaker.
Senator Mugeni.
Speaker, the only comment I wanted to make is let's deal with this clause very carefully. I've had the benefit of looking at all the anti-corruption agencies in Africa, including the most successful ones in Rwanda, the one in Botswana, the one in Ghana. You never mix declaration of assets with an anti-corruption commission. There is nowhere in Africa where that role is domiciled in an anti-corruption commission. So as we look at this amendment, we need to also proceed with caution, because we, as lawyers, we know that you don't mix functions of an investigative agency, okay, with a body that is receiving reports to look at any criminal aspect in it. So we need to pass a bill that can pass the test of the time. And we are not an island. We have many examples to learn from all over Africa, you know. In fact, if you go to Tanzania, the declarations are received by the public service. That's the regime that has been prevailing even in this country. It didn't come from nowhere. It's because we borrowed from what is happening in other jurisdictions. You go to South Africa, the same thing. So we need to be very careful that we pass a law that is aligned with the constitutional provisions, Chairman.
Thank you. Senator Enoch Wambua.
Chair, my problem with that clause as proposed is that, you know, Chair, we have the Unclaimed Financial Assets Act.
And I was thinking that maybe the best thing would have been to enhance that act to extend to assets, so that you don't pile a lot of work to the EACC, which is already doing the investigations, and then they go and do forfeitures and dealing with unclaimed and uncleared assets. Why can't we do an amendment to the Unclaimed Financial Assets Act and give that role to institutions under that act? Mr. Speaker, I oppose that proposal.
I put the question that the President's recommendation on Clause 6 be approved, division at the end. Next.
President's recommendation on Clause 8.
I propose the question that the President's recommendation on Clause 8 be approved. Chairperson.
Mr. Chairman, thank you very much. This is a proposal as regards the conflict of interest of a public officer and the situation or circumstances under which a public officer would be deemed to be having a conflict of interest existing. And in the observations of the committee, it's noted that the amendment or reservation as was proposed is to expand the conflict of interest to entail a real conflict of interest, perceived and or potential. And the committee did indeed we propose that we progress as it has been placed in the order paper. Chairman, thank you very much.
I put the question that the President's recommendation on Clause 8 be approved, division at the end. Next.
President's recommendation on Clause 12.
I propose the question that the President's recommendation on Clause 12 be approved. Chairperson.
Thank you very much, Mr. Chairman. The effect of the reservations under Clause 12 is to introduce an aspect in the text to the clause where the term good faith is introduced. And Mr. Chairman, I propose that we progress as per the order paper.
I put the question that the President's recommendation on Clause 12 be approved, division at the end. Next.
President's recommendation on Clause 16.
I propose the question that the President's recommendation on Clause 16 be approved. Chairperson.
Mr. Chairman, the effect of the reservations under Clause 16 from the Presidential Memorandum is to ensure that public officers are prohibited against receiving gifts or favors from persons who are working within the offices. And Mr. Chairman, I propose that we proceed with it as per the order paper. Thank you.
Senator Cherargei.
Mr. Chairperson, I don't know why the majority leader wants to disrupt the House. Mr. Chairperson, and I'm happy my learned senior counsel Okongo Mugeni is here. The import of clause number 16, Mr. Speaker, we have just said we don't know who our relatives are. This amendment is being done by World Bank and other foreign entities that do not understand the African culture. Mr. Speaker, where you come from, I know a number of your cousins, Mr. Speaker. And there are 1,001s, although in our culture you don't say the definite number, Mr. Speaker. This issue of bringing Wazungu type, you know, Wazungu get only 2 children, or they are there and only 1 dog. You know, Mr. Speaker, we need to be fair. In fact, Mr. Speaker, the writer of some book, I'm forgetting, and I only have 1 teacher, which I recognize as senior counsel, Professor Tomo Gienda, Mr. Speaker. That the definition, the importation of the law was even a proposal to Africanize. Mr. Speaker, this law that has been brought here does not recognize the culture and our way of life. Number 2, Mr. Speaker, you don't know your cousins. The last time you met them has been ages and ages. Others do not live. Then it says, where a public officer has a knowledge that your relative or a family member has received. So every evening, Mr. Speaker, you'll be going and asking your spouse, did you receive a gift today? Did you receive a favor? Will you be calling your relatives, like Professor Tomo Jenda, will you be calling your relatives in Migori? Mr. Speaker, in Kitui, in Nyamira? Mr. Speaker, this amendment is made in bad faith, and it negates anything about our African culture, and even religion, Mr. Speaker. Mr. Speaker, we oppose it with all our body organs because this thing is not fair, Mr. Speaker. It is not fair. Mr. Speaker, if we want to do things, even we are not saying corruption should not be fought, but we should fight corruption. Why should you deny my relatives to live their life simply because I am a state officer? If I have a child, which I don't, for record, who is above 18 years, they are paying taxes, Mr. Speaker. Why do you want to stifle? I don't know whether Senator Sikei children have reached the age of 18 years, but I doubt. Mr. Speaker, they are paying taxes. Why would you want to stifle their lives or to align their life to be with the life of the state officer, Mr. Speaker? Even the president's children, even the vice president, even the senators, even the governor's spouses and children and relatives, they have a right to live in this country and do their business, including your children, Mr. Speaker. So this thing is undermining not only the African culture, but even the religion and our way of life. Mr. Speaker, I totally oppose it.
Senator Osotsi.
Mr. Speaker, this is another amendment that is very annoying. And I think this house is the house that is going to help Kenyans. Because if you look at Article 115 of the Constitution, where the referral was based, it talks about 2/3. We can easily raise 2/3 here. The other house will have difficulties raising the 2/3. But us, we can raise 2/3 and reject even these referrals that have been made by the president. Because, in fact, the referrals contain amendments which are even worse than the initial amendments that were there, Mr. Speaker. So, Mr. Speaker, I want to urge the House that before we even vote for this, can we get our 2/3 members here? We can get 2/3 in this House, Mr. Speaker, so that we reject these referrals and even, if possible, delete all the clauses from this bill, Mr. Speaker.
Senators, please stick to your reservations on the amendment. Let us not deviate and start debating. I already reminded senators that we are not debating. And be brief. Senator Mogeni.
I think this is a very good clause. If I understand it well, it is saying we should not peddle influence. For example, Cherage may not have children, but there are leaders in this country of children. What this clause is saying, we don't want anybody to send gifts to the children of the president, deputy president, senator, or member of National Assembly. So we want discipline, yes. We don't want them to receive gifts. Because they come to Harambes and say, I was given a gift to bring to an Harambe. We want to bring that to a stop. So this one, let it stay. If you are a child of the president, deputy president, governor, senator, you should not CEO, you should not receive any gift. So even I'm saying this so that even the children of the president take note that the Senate is passing a bill that will prevent them from receiving gifts from anybody else on behalf or using the influence of the father or the mother. So this one I'm okay with it, but we start from the top. We start from the doorstep of the president, then come to the doorstep of the deputy president, then go to the governor, go to the senator, go to the women rep, go to the member of National Assembly, then we go to CEOs, everybody. So once this law is passed, Mr. Speaker, let us all be now equal. No receiving gifts. I support.
Senator Wambua.
Mr. Speaker, you know, we should also not pass laws in vain. And this is one instance where we are trying to pass a piece of legislation clearly just in vain. Because the Speaker, the definition of a relative and a family member in the African context, it's so wide that, I mean, unless you have nothing else to do, that when you wake up every day, the only thing you have to do is to find out from all your relatives who has received a gift, who has not received a... surely there are some things that, you know, I mean, and we even make the determination that I have knowledge of receipt of those gifts. The Speaker, Chairman, this is one recommendation that I am actually almost, and I don't want to cast aspersions on my colleagues in the JLAC, to imagine that this thing can pass the way it is. Surely, I mean, Chairman, this must be dead on arrival. Even if you wanted to, you cannot enforce it. How do you enforce this? How do you even do it? How do you do it? So this one, this one cannot.
Senator Mandago.
Yes, Chair. On the issue of gifts, Chair, where our problem is where it says you should have knowledge. If your relative receives a gift, for heaven's sake, I have relatives from all the way from Tanzania to Laikipia to West Pokot, and there is even a rumor that I have some relatives in Turkana. How will I tell that they have received a gift and what value? Whereas I would be inclined to agree with what Senator Omogeni is saying, but then let's amend the Unclaimed Assets Act so that we can put that there, because to me it makes sense, but not in this bill.
Senator Kavindu, what is your point of order?
Order 1. There is no quorum, Mr. Speaker. We have no quorum.
Let us confirm. Very well, Senators. We do not seem to have a quorum. We shall ring the bell for 10 minutes. Sergeant at Arms, 10 minutes.
Well, again, the House has faced a quorum hitch during the proceedings. This is a point of order that has been raised by the Honorable Senator for Machakos, Honorable Agnes Kavindu. The House was considering the President's recommendations on the Conflict of Interest Bill, a bill originating from the National Assembly, Bill number 12 of 2023. This is a business that was being considered at the committee of the whole. However, during that particular session or proceedings, the Honorable Senator for Machakos, Agnes Kavindu, indicated to the chair that the House does not have the requisite quorum that is needed during the proceedings of the Senate. And on clarification from the clerk, it was determined that indeed the House has lacked a quorum. The House, as you can see now, actually all the members, or rather a big number of members, have even walked out of the chambers. But we understand the business that was on the floor was the consideration of the President's recommendations on the Conflict of Interest Bill 2023. Some amendments that were moved, or some proposals that have been moved in the particular bill. Remember, these are recommendations that were forwarded to the Senate, or rather Parliament. For the Senate, the Committee on Justice and Legal Affairs went through the amendments as proposed, or the proposals from the President. And this afternoon, the committee was leading the members of the Senate in taking into consideration some of the proposals. There are a number of issues that the senators have taken concern with. Some of the clauses that have been moved as recommendations into the particular bill. One of the concerns that the members of the Senate have raised was with regards to the definition of a relative. One that they pointed out, the word affinity. That means a closeness to an individual. And their concern was with regards to whether that person has to be related to the individual or the public officer by blood, or just friendship, or just by association, which is what that affinity word means. And they had taken an issue with that particular word, indicating that there is need for a clear definition of the word relative to ensure that it does not alter its meaning regarding blood relations or friendship that is not blood related. And the members were indicating that that particular clause, or that particular recommendation, must be dropped, indicating that it is unfair and might as well undermine the freedom of association by the different public officers as they go about their duties. Some of the other concerns that the members have raised this afternoon regarding the recommendations, clause that was clause number 5, clause number 6, regarding undeclared assets, that they say that the EACC, the Ethics and Anti-Corruption Commission, does not necessarily have or need to have the sole mandate to implement the act, indicating that there is already existing law, and that is the Unclaimed Financial Assets Act. They were indicating that that act can be enhanced to be able to take into consideration that particular mandate and ensure that the House does not bombard the EACC with various mandates that can be undertaken by other bodies, including the unclaimed assets that can be undertaken by the Unclaimed Financial Assets body. The members also took an issue with clause 16. This is a clause that has indicated or is proposing that public officers, or that seeks to ensure that public officers are prohibited from receiving gifts or favors given by persons perhaps working within the offices that they are in. And these are some of the concerns that the senators have so far raised. Remember, this is a bill that was published on the 3rd of April 2023. Thereafter, it was considered and passed by the National Assembly with amendments on 30th November 2023, and it was referred to the Senate pursuant to Article 110 of the Constitution and was passed by the Senate again with amendments on 4th of June 2024. Taken back to the National Assembly, considered and rejected the Senate amendments to the bill on 24th of July 2024. And consequently, pursuant to Articles 112 and 113 of the Constitution, a mediation committee was appointed to consider and develop a version, or rather a mediated version of the bill that may be passed by both houses. And the mediated version of the bill was approved by the National Assembly on 5th of December 2024, and by the Senate again on the 8th of April 2025, following which it was transmitted to the President for assent. And by a memorandum dated 28th April 2025, His Excellency the President referred the bill back to Parliament with reservations, recommending the reconsideration of a number of clauses, and that is what the House has been doing this afternoon. Just to point out on the clauses that the President recommended for reconsideration include Clause 2, Clause 5, Clause 6, Clause 8, Clause 12, 16, 17, 18, 20, 30, 31, and 35 of the bill. And these recommendations were initially considered by the Justice and Legal Affairs Committee of the Senate. And this afternoon, the committee has been leading the House at the Committee of the Whole in considering these recommendations. But what we have seen so far, before the interruption on the point of order indicating that the House lacks a quorum during its proceedings, the House was considering clause number 16, the one that the proposal indicates that or seeks to ensure that public officers are prohibited from receiving gifts or favors given by persons known to them or working within the offices or the public service offices. And this is the point that the Senator for Machakos rose at a point of order to indicate that the House has lacked quorum. Well, let's listen in.
Chairperson. Chairperson, proceed.
Honorable Speaker, I beg to report that the Committee of the Whole on the Conflict of Interest Bill, National Assembly Bills number 12 of 2023, has lacked quorum to proceed with the business.
Leader of Majority, the quorum bell rang for a period of 10 minutes. Unfortunately, we were unable to raise the quorum, and the the 10 minutes had since lapsed, and the chairperson has reported. Order, Senate Majority Leader. Senator Cherargei, Majority Leader.
Standing order.
Take your seats. Senate Majority Leader, take your seat. Senator Aaron Cheriot. Senator Professor Ojenda. Honorable Senators, having failed to attain quorum at the expiry of 10 minutes in the committee, the Senate stands adjourned pursuant to Standing Order 41-2B until tomorrow, Thursday, 10th July 2025 at 2:30 p.m.